Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I recognize that when you guys watch a lot of my videos, and this is not my intent, but I am talking about infuriating topics. And today we're going to be talking about Duncan v. Bonta. We're going to be talking about a magazine ban. And yeah, I could go through the rules of law, and I've geeked out with you on it 1,000 times already, in common use, dangerous and unusual and all of that. But again, when you're done with the video, you're just going to be all ticked off. Today, let's try to look at things a little bit differently. Let's look at through the eye of a very sarcastic individual, because I don't know if you guys have realized this. I'm a huge fan of sarcasm around here, and maybe we've just run out of other arguments to make. So today, let's go through an amicus brief and let's talk about when sarcasm is the only response left to gun control. Okay, America, we have talked about this case a lot lately, and that is the case of Duncan v. Bonta. That is the granddaddy of them all when it comes to magazine bans, and it now sits before the United States Supreme Court on a petition for certiorari. What we're going to focus on today is an amicus brief brought to us by our good friends over at the National Association for Gun Rights, which means that the author of the brief is none other than Mr. Barry Arrington, who I have already told you is absolutely one of my favorite brief writers because, again, his briefs are brief, they have some very dry humor, and this one is chock full of sarcasm. Now, there are several points that we're going to illustrate, although the memorandum actually provides for a lot more points than we're going to talk about today. But some of the points that I really want to emphasize out of Mr. Arrington's brief start with, number one, the lower courts hate Heller. Yeah, it's the reality of the situation. They've hated it since the day it was published, and they've done everything they possibly can to undermine it. As the amicus party points out, unfortunately, compliance with Heller's clear mandate has never been a top priority of the circuit courts. From 2008 to 2022, every circuit court failed to apply Heller properly. And then I want you to take a look at the citation associated therewith to take a look at all of the cases. And the list is long, as you can see, where a lower court intentionally did not apply Heller correctly. The second point, though, is if you think the courts hate Heller, you ought to see how much they hate Bruen. As Mr. Arrington points out, sadly, Bruen's admonitions fell on deaf ears. The lower courts continue to be bent on distorting this court's Second Amendment precedents. And have things gotten better since Bruen? Because we all thought they would. No, I want you to go ahead and take a look at this citation now that cites to the litany of cases, and they are scattered all throughout the country, wherein the rule of law, clearly announced in Bruen, was ignored by a lower court. Which leads Mr. Arrington to the rather obvious conclusion that, we really don't need to let this thing percolate anymore, because what percolation really translates to is giving courts more time to continue to defy the clear precedents of the Supreme Court. As he puts it, in summary, the circuit courts unanimously defied Heller from 2008 to 2022. Even though those courts were egregiously wrong, there was no circuit split, and a split was obviously never going to develop. Bruen called for a course correction, but nothing changed. The lower courts that have addressed firearms bans since Bruen have, without exception, continued to distort Heller. Again, there is no circuit split, and there is little reason to expect one will develop. In light of this history, there cannot be the slightest doubt that Justice Thomas was correct when he said further percolation is of little value. Now, the third and perhaps most important point in this very well articulated brief is, number three, the potential abuse of freedom is the price of freedom. Let me explain to you exactly what the amicus party means by that. The circuit court upheld California's arm ban because criminals sometimes use the banned magazines. As this court has recognized on several occasions, however, criminals' use of a firearm is not a reason to ban law-abiding citizens from using them. The potential for abuse of a freedom is the price we pay for that freedom. Now, listen, amongst people like me and Mr. Arrington, when we're geeking out privately about memorandums, we will always say that anytime an opinion from a court starts with tales of horror and mass shootings, you know exactly where that opinion is going. Now, that is normally left to private conversations amongst lawyers. Mr. Arrington, God bless him, has actually put it in writing for the Supreme Court to see. When a judicial opinion begins with an emotional appeal instead of a legal analysis, hold on to your wallet. But this is an important thing because this potential for trying to use criminal activity to justify taking things away from otherwise lawful and responsible people is not only ripe for abuse, as we've seen already, but there is no other constitutional right that is regulated in that format, as Mr. Arrington points out when compared to the First Amendment. Moreover, as this court has stated in the First Amendment context, a free society prefers to punish the few who abuse rights after they break the law, rather than to throttle them and all others beforehand. The fourth issue is that the Ninth Circuit theory proves too much. And again, this is where sarcasm and using their own words actually proves the point. As Mr. Arrington points out, the Circuit Court started on the right track when it stated, for the right to bear arms to have meaning, the amendment's text must carry an implicit corollary right to bear the components or accessories necessary for the ordinary functioning of a firearm. But then in a moment of sarcasm, the court went off the rails when it stated, a large capacity magazine is a box that, by itself, is harmless. It cannot reasonably be described as an item that a person takes into his hands or uses in wrath to cast or strike another, nor can it be reasonably described by itself as a weapon of offense or armor of defense. Without an accompanying firearm, a large capacity magazine is benign, useless in combat for either offense or defense. But then, and this is what I love taking their own words and saying, well, if that's the logic, what about this? Because as Mr. Arrington points out, this argument proves too much, and it is easy to see why. Substitute any other vital component of a firearm into the last sentence of the above quotation. And then as he points out, without an accompanying firearm, a barrel is benign, useless in combat for either offense or defense. Replace that with trigger. Replace that with hammer. Replace that with bullet, which of course leads the amicus party to properly point out examples could be multiplied. The point is that every component of a firearm is, standing by itself, benign and useless in combat for either offense or defense. Yet no one argues that barrels, triggers, hammers, and bullets can be banned. And then finally, and this is a brilliant argument actually, and we talked about it on this video right here because it was first introduced in the amicus brief that he authored in the matter of Gators Customs Guns versus State of Washington. A challenge to Washington's magazine ban is that right now, courts such as the Washington State Supreme Court and here, the Ninth Circuit, well, they're operating under a magic bullet theory. Now, we used to call it the limitation du jour, right? That is that for some reason, 10 is just the arbitrary number that is the in thing today. But as Mr. Arrington very wisely calls it, it's a magic bullet theory because to some point, all magazines apparently are protected by the Second Amendment. But then, at some point, once you add this magic bullet, it goes over a threshold where the magazine goes from being protected by the Second Amendment to the Second Amendment not even applying. And the problem is, we don't know where that limitation is, and of course, I imagine it could change. As amicus party points out, to be sure, the court hinted, but did not actually hold, that the dividing line between covered by the text and not covered by the text may be based on minimal functionality. Well, that's a huge problem, isn't it? Because if we're talking about minimum functionality, 1 round is minimum functionality. So what stops a state like California from now being at 10, going to 7 next year, going to 5 the year after, and you see where this goes, okay? And ultimately, and this is a logical conclusion, the amicus party here points out, it would be truly astounding, however, if the lower court believed the government has the power to require all semi-automatic firearms to be converted into the functional equivalent of single-shot breech loaders. But nothing in its opinion limits California from doing precisely that. Okay, kudos to Mr. Arrington. This is a really, really fun to read amicus brief. I don't say that about a lot of legal briefs. They're not usually fun to read. Listen, we're going to go ahead and link up the amicus brief down below so you can geek out on it for yourself. You don't have to take our word for it. We're also going to put a link down there since this comes from the good folks over at the National Association for Gun Rights. We're going to put a link down below in case any of you want to show them some love. Now, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get all the Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
They're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies, actually leads to that result a little bit. But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore. What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company, not the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people and really the citizens of our country somebody that's going to be there when they need us most. That was what we prided ourselves on, and I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.